You've just been served with child custody papers, this is going to be your sign to take action. If you don't take action, if you don't do what's necessary, the process is going to move on without you, and the judge is going to make decisions without hearing your voice. What's going on, guys? I'm Mark Reel Jr., the Father's Rights Attorney. I'm the founder and CEO of Real Father's Rights, and today I'm going to take you through a masterclass on California child custody. Now, child custody in the state of California is something that's near and dear to my heart. It's how family law found me. I personally spent time in the court system. As we get further along in these lessons, we're going to go more in depth. We're going to cover individual topics, but the goal today is going to give that 30,000-foot view so that you understand what you are going into. So in the state of California, child custody is determined by a law that essentially says the judge has to make a decision as to what is in the best interest of the child. Now, I hate this law. I say it's more of an excuse than a law, but in 2023, this is what we have to deal with. Now, the best interest of the child standard takes a number of factors into account. It's going to take into account relationships between the parents and children. It's going to take into account siblings and step-siblings. It's going to take into account what roles and what duties were filled by each parent. So what advice can I give a father going through a family court and having issues with child custody? Number one is we want to avoid the number one mistake. The number one mistake men make is sticking their head in the sand. The number of men that hire us 2 weeks, 1 week, or maybe even days prior to their custody hearing, panicked, frantic, not knowing what to do, not having filed the appropriate documents, is a significant number of our clients. So if you're watching this and you've just been served with child custody papers, this is going to be your sign to take action. If you don't take action, if you don't do what's necessary, the process is going to move on without you, and the judge is going to make decisions without hearing your voice. Now, with that best interest of the child standard, what can you do initially to show that it is in the best interest of the child for you to have significant custody? You need to show that you have a past relationship, you have an existing relationship, and that you can personally and alone provide for the needs of a child. The number one issue that our clients run into in regards to getting 50-50 custody or getting the custody arrangement they want is their work schedule. I understand that when you are in your relationship, when you were married, whichever one it was, mom and dad play specific roles. Okay, mom gets them off to school, or mom picks them up, dad takes them to the doctor. You have to understand, as a single father, you have to be able to show the courts that you can fill all of those roles. This may mean making adjustments professionally. This may mean showing that you can make these changes or showing that in the past you've done these things. We have so many men come to us and they wait until the last second. They're not flexible in their schedules. They're not able to meet the kids' needs, and that usually is the biggest challenge in terms of us getting that equitable custody arrangement. So over the next couple of lessons, over the next 40 to 50 minutes, we're going to dive deep into specific topics that impact child custody, from sexual abuse and domestic violence allegations to how to deal with a custody evaluator and the mediation process that every single request to modify custody must go through. So my goal is, over the next 50 minutes, to provide you with the knowledge to successfully navigate the family court system to get the outcome that you and your children deserve.